Okay, Assalamualaikum students. Today we will continue with topic 1B, which are the environmental factors influencing IR. Yeah? The first external environmental factor is the law. Okay, so because employment relationship is related to few acts which are implemented. These acts, especially Malaysian labour law, are the Industrial Relations Act 1967, the Trade Union Act 1959, and the Employment Act 1955. The acts will be revised from time to time to suit the environmental changes, i.e., the economic or social. Like for example, that I have explained before, the gig economy, and now the economic environment has also changed because of the gig economy, which did not exist in the past. Okay, so now maybe the laws need to be amended to suit to cover the gig economy, which though there is a change, okay, in the form of how employment relationship is so it's different now. Previously there's a contractual in nature, which is where the what do you call conventional ways, which makes an employees to an employer, and they sign a contract, and they send offer letter and all that. But now it has evolved into the employment relationship has evolved, where now employees are no longer conventional. For instance, food panda workers, food panda riders, and grab drivers, they are not termed as employees. They are not conventional employees, but they are different in a way. They are not termed as employees, so that makes it difficult because our laws only recognize the rights of employees. So when you're not an employee and you're just a partner, not in the sense of partner, business partner, so they don't have the rights. Certain rights and obligations of employers are not cannot be seen, okay, cannot, and it's not practiced. So because of this, it is quite unfair to the employees, because they're not covered by all the privileges or benefits that the employees of a company covered by, for instance, and also the mandatory benefit does not apply to them. The mandatory benefit by the government is not applied to them, such as annual leave, such as maternity leave, even salary, hours work, they're not covered. They did not receive SOCSO, EPF contribution by the employers. So it seems that the employers are getting away with a lot of things here. So this makes it very difficult, okay, and unfair, because although they are termed as part-time, but some of them works full-time. So as a full-time employees, it is 48 hours a week, but they have to work like 60 hours in order to get that extra 100 ringgit, which I think is quite oppressive. Okay, so the generally government will give priority to the harmonious relationship between employer and the workers, and as we've seen, there's a conflict previously between food panda riders and food panda, okay, and also grab, because they can just terminate without reason. They do not have to follow the rules of the stand of the principle states by the industrial court. Okay, so Employment Act 1955, the scope and the application would be the EA and labour ordinances. The Sabah and Sarawak enforces labour ordinances, okay, not Employment Act. Only Peninsular Malaysia applies Employment Act. Okay, so this Sabah Sarawak ordinance and EA are not applicable to employees of the government of Malaysia, government of any state. Okay, government of Malaysia, such as the ministry workers, they are all of government of Malaysia, Ministry of Health, Ministry of Defence, government of any state, which is the state workers, under Menteri Besar and under Chief Minister, all the state employees, they are under the state government, like the land department, those falls under the state government. Wisma Negeri, Wisma Darul Aman, and then the local authorities would be the Majlis Perbandaran Council, Local Council, Majlis Bandaraya, City Council, Majlis bandar before Perbandaran tu, and then employees, these are all the workers of local authorities or employees directly employed by any statutory body established. Statutory bodies would be those bodies that have their own acts, okay, like universities, LHDN, Perkeso, EPF, these are all statutory bodies. Okay, they are usually part government, part private. Okay, not really private. They can generate their own income. So their budget doesn't come 100% from the government like the ministries. So the Act provides for minimum standards in relation to terms of employment for workers covered by minimum standard. So any organisation operating in Malaysia would have to follow this minimum standard. They cannot give below the minimum standard, meaning if the annual leave, if the public holiday that is been given has been stated, specified is 11 days, they cannot give lesser than 11 days. They can give minimum 11 days, or they will have, if they want to have a good reputation, they will provide more than that. They want to be known as a good employer, they will give like 15 days, for instance. So 15 days, if they give 15 days, then the 11 days will be void. The more favorable terms will be in use. Okay, right. But that does not stipulate any minimum amount of wages that should be provided to them. They don't have any statement of how much is the minimum wage, because this is covered by the Minimum Wage Order 2012. This order will determine what is the minimum wage that have to be paid to employees in Malaysia, especially in the private sectors. So the Act is administered by the Labour Department, even Peninsular Malaysia Labour Department, and applied to Peninsular Malaysia and the Federal Territory of Labuan, the Employment Act, because in Sabah Sarawak they use Sabah Sarawak Labour Ordinances. Okay. So the EA applies to any employee who is defined as any person included in the first schedule to the Act, or in respect of whom the Minister makes an order under Section 2, Subsection 3 or Section 2A. So pursuant to the schedule, the Act applies to any person irrespective of his occupation. So it doesn't matter what the occupation is, who has entered into a contract of service. So under EA, it is termed as contract of service. Under IRA, it is termed as the contract of employment. Okay, with an employer under which such person's wages do not exceed 2,000 a month. So workers covered under EA, where the starting salaries do not exceed 2,000 a month. Okay. And wages included commission, commission, subsistence allowance and overtime payments. So basic wage is 2,000. Commission semua on top of that. So with effect, 1st August 1998, persons earning more than 2,000 but not more than 5,000 a month can avail themselves of redress in the labour court. So they can bring, if they have a conflict or problem with their employers and it is not settled through the grievance procedures or processes, they can redress their issues in the labour court. So dispute in respect, especially in terms of wages or other payments, but not statutory benefits. This is another term. Mandatory benefits is also the same as statutory benefits, which are all the benefits provided under the in Employment Act 1955. It is known as statutory benefits. Okay, as you have learned in HR, what the benefits given by the companies on top of all the statutory benefits or mandatory benefits that has to be given because they have to comply to the Employment Act are termed as discretionary benefit. Okay, it's up to the discretion of the company to give what extra benefit, but the minimum is by following the EA. So until 5,000 still you can redress if you have any issue, okay, in the labor court. And you bring to the labor court when there is no termination yet. Okay, when there is no termination in place, then all your issues and conflict with your employers usually you bring to the labor court. But when there is when termination takes place, then usually you bring the case to the IR department and to be referred to industrial court. So this act also applies to EA, to any person who, irrespective of the wages he earns a month, has entered into a contract of service with an employer in pursuance of which he is engaged in manual labor. The minimum wage is 2,000, and also another condition would be he is engaged in manual labor, including as an artisan or apprentice. Artisan is when you are working in a special craft, for instance, carpentry or shoemaking, or dyeing, mechanics, all those things, or apprentice. So he is engaged in the operation or maintenance of any mechanically propelled vehicle for the transport of passengers or goods or for commercial purposes. So if he uses manual in his work to or he have to use to operate mechanically propelled vehicle, because when you operate mechanically propelled vehicle you will have to refer to a manual, This is what you call manual workers or manual labor. And not only those who work in that type of employment, but also if he supervises or oversees other employees engaged in manual labor, he is also entitled to or covered by EA. So that's why salary is from 2,000 to 5,000. So because supervisors usually their starting salary may start more above 2,000, but because they oversee manual labor, they are covered. And also he is engaged as a domestic servant. Domestic servant would be either you're a driver, you're a gardener, or you're a maid. They are covered by EA. Okay, so the EA prescribes minimum terms. So even if they're from Indonesia, or they are covered by EA. Okay, so prescribes the minimum terms and conditions of service. However, it does not prohibit any condition of service agreed between employer and employee which are more favorable than those provided under the Act. So under Section 7A says, if you provide a more favorable terms, then the favorable terms will supersede the minimum standard, and thus will require the minimum standard to be null and void. So any matter that is not covered by the Act is left open to the parties concerned. Not covered, then you have to negotiate between the two parties and to reach mutual agreement by themselves under Section 7B. Okay. So however, any term of condition of contract of service which is less favourable to an employee than that prescribed by the Act shall be void and of no effect, and the more favourable statutory provision shall be substituted under Section 7 that I have just explained before. I'll say, okay, now we go into Industrial Relations Act 1967. So what is the difference? This act provides for the regulation of the relations between employers and employees and the trade unions. The EA covers or regulate relations between employers and individual employees. However, the IRA regulates the relations between employers, employees and their trade unions. So ada tambah satu, trade union. So it is aimed at safeguarding the legitimate rights and interests of employees and their trade unions. It helps in prevention, settlement of any difference or disputes arising from their relationship. Ni bila ada trade union, also when they involve termination or involve trade union, then IRA will take place. Okay, so the Act also deals with trade dispute and matters arising therefrom, covers all workmen regardless of wages. This one different from EA because it covers all wages. Doesn't have to be 2,000 to 5,000. Even if your salary is 10,000, but if they involve trade union or termination, then this Act will take place. Okay, so the Act is administered by the IR Department of Malaysia and applies throughout Malaysia. So the application, unlike